Thank you, President. Without further ado, we would like to introduce our first panel of today. In this section entitled Balancing Data-Driven Marketing and Sales with Data Privacy, our speakers, Mr. Aaron BLEASDALE, Managing Associate General Counsel, Head of Data Privacy Legal, Asia Pacific HSBC, Ms. Ada CHUNG Lai-ling, Privacy Commissioner for Personal Data, HKSAR, and Ms. Carmen TANG, Senior Partner, Check and Associate LLP, will discuss the conflicting relationship and the ways to strike balance between data-driven marketing and sales practices. Please welcome our speakers of this panel, which will be moderated by Mr. Wilfred Ng, Senior Legal Counsel, Tencent. Please.
Morning. Thank you everyone for joining the first session of this conference, and to kick off today's meeting, hopefully with a very fruitful and insightful discussion regarding data-driven marketing activities. Today I'm very honored to be joined by my esteemed colleagues on the panel who are all established experts in the field of data privacy and data protection. And I very much look forward to today's discussion because when I first got in touch with the topic, I feel this is very much echoing with the spirit of today's theme, being the corporate connector. As all of you know, as in-house advisors and lawyers, we're often at this intersection between our stakeholders' interests and the compliance demands of our enterprise, our companies. And this is very much a vindication, I believe, being data-driven marketing activities, of how all these sometimes conflicting, sometimes facilitating set of interests interact with each other. Today's structure is briefly as follows. As some of you may know, we will have individual presentations from our established speakers on the panel. And then this will be followed by questions facilitated by myself and also by the participants in the conference. If you have any questions, feel free. If you're joining by Zoom or if you're here today attending, feel free to raise your hand and we'll address any questions on any topics that we have discussed. Without further delay, if I can invite Commissioner Chung first to give her presentation on the overall lowdown on the direct marketing regime in Hong Kong, and then we will follow up with subsequent presentations from an enterprise perspective and also from the general industry legal challenges within the marketing space, especially from a data-driven perspective. So may I please invite Commissioner Chung. Thank you.
President, distinguished guests, ladies and gentlemen, good morning. And thank you very much for having me here. Today, I'll be talking about balancing data-driven marketing and sales with data privacy. I believe that marketing and sales must be one of the most important areas on which the advice of in-house lawyers are sought. And in today's presentation, as a regulator, I will try to highlight the basic regulatory framework on direct marketing under the Personal Data Privacy Ordinance. I will then give you a few examples of the more common pitfalls that I believe you should avoid in your daily operation. Let us look at some figures first. From this graph, you will see that in the past 3 years, my office has received around 115 complaints every year relating to direct marketing. And for this year, up to the end of August, we have already received 63 complaints in the area of direct marketing. And I believe that by the end of this year, the figure will be more or less 150. So it is in line with the trend over the years. As some of you may recall, the Personal Data Privacy Ordinance was amended back in 2012 to introduce a brand new regime to regulate direct marketing. And this is actually one of the follow-up actions to the famous Octopus incident. I don't know whether the in-house counsel of Octopus is attending, but I'm just giving a factual account. The incident, as you may recall, was happened back in 2010. And 2 years later, the ordinance was amended. And in that incident, a major blunder, I would say, was made by the company in that customers' personal data was sold to another company for gain. Firstly, what constitutes direct marketing? It's very important to understand the basic concepts for this particular discussion. Direct marketing is defined under the ordinance to mean the offering or advertising of the availability of goods, facilities, or services, or B, the solicitation of donations or contributions for charitable, cultural, philanthropic, recreational, political, or other purposes through, remember this name, direct marketing means. And direct marketing means is in turn defined to mean the sending of information or goods addressed to specific persons by name. This part is most important. It has to be addressed to specific persons by name. And the dispatch mode is by mail, fax, electronic mail, or other means of communication, or making telephone calls, again, to specific persons. So if you look at the definition of direct marketing means, it appears that there is a loophole in the regulatory regime, in that if the message is not addressed to specific persons by name, this would fall outside the purview of the regulation. Is that the case? I don't believe that this is a loophole. I do believe that the legislative intention at the time is not to regulate or not to cast the net too wide as to unnecessarily stifle legitimate commercial activities. And if you think further, if the message is not addressed to specific persons by name, it's just a general message, it may not involve any personal data at all. It may not involve the collection or use of personal data. And if no personal data is involved, the PDPO, the Personal Data Privacy Ordinance, would not apply. And palpably, I do believe that it is the rationale governing the way direct marketing means has been drafted and applied. Essentially, under the ordinance, the direct marketing regime is divided into two main areas. The first area relates to the use of personal data in direct marketing. And the second area relates to the provision of personal data by the data user. That is a company, can be a company, or can be a sole proprietorship, or can be an individual, to the third party for direct marketing. So let us look at the requirements for the first particular area, the use of personal data in direct marketing. Under the ordinance, there are certain steps a data user has to take before he can use the personal data for direct marketing. and we call them specified actions under the ordinance. The specified actions mainly comprise notifications, the provision of a list of prescribed information, and also the receipt of the necessary consent. And I will be covering this one by one because they are the key components of the essential requirements before you can use the personal data of your customer in direct marketing. The notification requirement essentially requires the data user to inform the data subject, that is the customer, that he intends to so use the personal data in direct marketing. And the data user or the company may not so use the data unless the data subject consents to it. So you have to inform your customer of that, about his or her right to opt out. And that is a list of information, which we call prescribed information, to be provided to the customer as well. The kinds of personal data to be used, the classes of marketing subjects. This is also important. It means the goods or services which you are going to promote through the direct marketing, and a channel through which the data subject may communicate his or her consent to the intended use. So you have to give the customer a channel, whether it is by email, by telephone, or by sending a reply through clicking a box on the internet. And the third requirement is that you have to receive consent from the customer before you can use the customer's personal data. And the consent in this particular context can be in writing or can be given orally. So there are several requirements you have to go through before you can use the customer's personal data in direct marketing. Let me turn to the second area of covered by the regulatory regime, which is the area of provision of personal data to third parties for direct marketing. It is very similar to the scenario of Octopus, the provision of customers' data to another company for that company to carry out direct marketing. The requirements are actually very similar. Notification requirement, provision of prescribed information, and also the receipt of consent. But in this case, notice the differences are that the notification has to be in writing, and the consent has to be in writing as well. So there are some key differences between the two regimes. And in this case, the prescribed information will also need to cover the fact that if the data is to be provided for gain, that information has to be provided to the customer as well. So you have to be frank and transparent in the first place, and you have to tell the customer what personal data you are going to use, the classes or marketing subjects involved, and also the channel through which he or she may indicate his consent. Rights of data subjects, that essentially means the rights of customers. The ordinance expressly covers the rights in the relevant provisions. And essentially it means that even if the customer has given his or her consent to the use of his or her personal data in direct marketing, he can withdraw the consent at any time. And therefore, the ordinance provides that the customer or the data subject can request the data user or the company to cease to use the data in direct marketing. And secondly, in the second area, the customer can request the data user to cease to provide his personal data to another person for use in direct marketing. And also, the customer can request the company to notify that third party to cease to use the data in direct marketing. And the ordinance even goes further and say that once the data user receives such requests from the customer, the data user must comply with the request without charging any fees. Let us now turn to the part on liabilities and offenses. It's important to note that I've just outlined all the key or the most important requirements under the regulatory regime. And it's important to note that any non-compliance or contravention of the requirements may constitute a criminal offense under the ordinance. For example, if the company in question uses the customer's personal data in direct marketing without obtaining the necessary consent, this would constitute a criminal offense under the ordinance. And I will be talking about some prosecution cases later on. And for this offense, it attracts a maximum fine of 500,000 and imprisonment term of 3 years. It is rather a high level when you compare this to the other offenses under the PDPO, because at the moment, for most other offenses, the maximum fine is only $10,000. And that is why we are reviewing the ordinance to, if possible, to align the penalty level. The same, you will see that the same penalty level actually applies to a data user who, when using the a data subject's personal data in direct marketing for the first time, fails to inform the data subject of his or her opt-out right. In addition, if the data user fails to comply with the request to cease to use the personal data in direct marketing, he would also have committed an offense under the ordinance. So essentially, if you fail to comply with the requirements under the ordinance, you may be liable to a criminal offense. And similar offenses actually apply in the context of the provision of personal data to the third party for use in direct marketing. In other words, if the company in question, we can also use the octopus example. Nowadays, we decide to sell the personal data of customers to another company for gain, but without obtaining the consent of the customers in question, it would be a criminal offense nowadays. And it attracts maximum fine up to $1 million because the provision of data is for gain. And if the provision of data is for gain, the imprisonment term is also increased from 3 years to 5 years. And for the other offenses, they are very similar to those in the first area, in the area of using the data subject's personal data without consent in direct marketing. Statutory defense. I've been talking about liabilities, criminal offenses, so I think to complete the picture, I should also talk about statutory defense. Under the ordinance, it is provided that for all these criminal liabilities, the data user has a statutory defense. And the data user, if the data user is able to prove that he has taken all reasonable precautions and exercised all due diligence to avoid the commission of an offense, he would have a statutory defense. Of course, whether the statutory defense is available to the defendant depends on the facts of each particular case. But in order to invoke this defense, I would highly advise data users to put in place a proper system for the handling of data to demonstrate that he has exercised all reasonable precautions and exercised all due diligence to avoid the commission of any offense under the ordinance. It is advisable for companies to put in place a proper system in the first place. It's not until something has gone wrong, then you try very hard to find some evidence to prove that you have taken all these reasonable steps. I will now turn to the more common direct marketing pitfalls that we have noticed from our enforcement experience. The first one is about the form of consent. As I have mentioned in the earlier part of this presentation, when a company uses personal data in direct marketing, the company needs to obtain the consent from its customers. And the consent can be in writing or the consent can be given orally. However, the ordinance also provides that if the consent is given orally, the company has to confirm the consent within 14 days. And for the provision of personal data to other parties for direct marketing, the consent can only be in writing only. So only a consent is valid, not oral consent. And practically, I think as a lawyer, I think I will advise you as your client to secure written consent as far as possible in order to avoid any with the customer and to avoid any understanding with the customer. Because if you got the consent written form, you can keep a record of that consent and also you can update it readily and more easily. The second common pitfall is in the area of the design of the consent form. Again, to remove any possible doubt about whether there's a consent or not, and about whether the consent was voluntarily given, we strongly recommend that the form be designed in a manner that separates customers' agreement to the terms and conditions of the provision of service from the customer's consent to the use of his or her personal data for direct marketing. In other words, we will advise companies not to bundle the consent together. If you bundle the consent together, the customer might be misled to just put a tick in the relevant box, but actually he wanted to opt out from the direct marketing option. So the design of the form should ensure that the customer are given clear and also genuine choice to decide whether he agrees to the use of his or her personal data for direct marketing. Let me now turn to some cases. From our enforcement experience, actually many prosecution cases, I would say, relate to the withdrawal of consent and relate to the use of personal data for direct marketing despite the withdrawal of consent. Over the years, we have prosecuted quite a number of cases in this particular area. And if I may use as an example, last year, in September last year, there was a ruling by the court convicting an estate agent. And in that case, the property purchaser made an opt-out request to an estate agent. I don't want to mention the name here. You can see it from the picture. He made a request to the estate agent, to the firm itself, but he subsequently received a direct marketing call from a staff member of the estate agent asking him if he wanted to sell his property. Of course, he was quite angry. He made a complaint to my office. And after making some initial inquiries, we referred the case to the police for consideration of prosecution because we considered that there was prima facie evidence of contravention in the case. And last year, the case was heard and the staff member was convicted. And the judge in the ruling actually expressly said that the PDPO, the Personal Data Privacy Ordinance, not only applies to companies, but it applies to individuals and staff members of companies as well. So you have to be careful. Even for employees of a company, they have to be careful not to contravene the ordinance. If they are calling any particular customer, I will strongly advise them to check the opt-out list first. Because in this particular case, the estate agent, the staff member failed to check the opt-out list, and that's why he continued to call the customer in question, and that is a criminal offense. And at the end of the day, he was held to be liable. If I may share another case with you, in this case, the telecommunications company pleaded guilty to violating the direct marketing provisions. And in this case, actually, it stemmed from a complaint lodged with my office. The complainant has subscribed broadband service with a telecommunications company, and again, he opted out the use of his personal data in direct marketing. Notwithstanding that, the complainant still received free direct marketing calls promoting a new service plan. I do believe that many of us have this kind of experience. Over the past few days, I have so many calls from my telecommunications company agent asking me to renew my plan. And the complainant, of course, was quite angry. He made a complaint to our office, and we have made some inquiries into the matter. And the case was again referred to the police for further investigation and prosecution. In 2020, about 2 years ago, the telecommunications company was charged, and the company pleaded guilty to 6 charges and was fined $12,000. I would say the lessons from this case are that never ignore customers' opt-out requests. And for companies, it is highly advisable for them to develop and implement policies as well as provide proper training to employees in order to ensure that the requirements of the ordinance are complied with. I will also advise that companies should always keep an opt-out list and maintain and update the opt-out list whenever they receive any opt-out request. Because it's really no point if you are not updating your opt-out list. If the opt-out list is outdated, you are putting your staff members in trouble. Let me wrap up this part of the presentation by another case. This case illustrates that the failure to adequately inform the data subject can amount to a criminal offense. This relates to the notification requirement. And in this case, the complainant, the lady in question, received an SMS on her mobile phone addressing her by her surname from an insurance agent for promoting a new saving plan. And the lady said that she did not know the agent. The insurance agent was not her agent. And he questioned how he obtained her surname and telephone number. The agent failed to provide a reasonable reply or a satisfactory reply. And neither did the agent notify the lady of her opt-out right. So apparently there are 2 contraventions here. Firstly, failure to comply with the notification requirement, failure to provide the prescribed information, and also failure to inform the complainant, the lady, of her opt-out right. At the end of the day, the agent was charged and he was convicted as a result. So be careful. Any non-compliance or contravention of the requirements under the ordinance may constitute criminal offense. And so you better be careful whenever the company seeks advice from the division, from in-house counsel, from your legal division. You have to give proper advice based on the law. So I've come to the end of my presentation. For those of you who are interested, you are most welcome to take a look at our website. We have issued a guidance on direct marketing, which provides, I would say, very helpful advice on quite a lot of issues in this area. So if you're interested, please go to our website and take a look at the guidance. For today's PowerPoint, I will also upload it at our webpage. So there's no need for you to make any photos. Thank you.
Thank you very much, Commissioner Chung, for a very detailed run-through of Hong Kong's PDPO direct marketing regime, which I believe also sets a very good foundation for the 2 subsequent presentations for today. If I can now turn to Aaron, if you can hear us clearly, thank you again for joining us remotely today. And I'll pass the time to you to give us a perhaps your thoughts and some of your practical tips, if I can cue you in that manner, particularly from a data user's perspective, with regard to data-driven activities, and particularly interested in your views, in the lens of an in-house advisor as well as your internal stakeholders of marketing teams. So thank you, Aaron.
Can I do a sound check, Wilfred? Am I clear? Can you hear me, Wilfred?
Can you hear us, Aaron?
I can. Can you hear me? My microphone is working.
I'm not sure if you're muted.
No, I'm not.
Oh, okay, we can hear perfectly. Thank you.
Okay, great. Yeah, great. So yeah, apologies first off for not being there in person today. One of my kids brought back a stomach virus over the weekend, and it's been knocking down members of my family one by one. And today is my turn. So I will be making this presentation, but I'll be signing off right after. So apologies to Wilfred, Ada, Carmen, and the Law Society as well. But thank you for your time. I'll share my deck now. Right, so can you see that, Wilfred?
Yep, thank you.
Great, yeah, fantastic, thank you. My name is Aaron BLEASDALE, and I'm the Regional Data Privacy Lead Lawyer for HSBC in Asia. The views I express here are entirely my own, I have to say that. I won't try to compete with Ada or Carmen on explaining the law. I think that's really well covered. But I will try to share some insights on marketing and data privacy compliance, as Wilfred mentioned, from the data user's perspective. I know today's a long day, probably pretty long for me too, so I will try to keep things light. Banks have been in the business of protecting customer data for hundreds of years, but data privacy is a bit of a different beast. Data subjects have an awful lot of rights of varying kinds in respect of their data, and data users have a new range of responsibilities. And as our society collects and uses more and more data in more complex ways, fulfilling these responsibilities can actually be a little bit more of a challenge. Marketing and analytics teams may get excited about hoovering up personal data whenever they can, but anyone in the data privacy space knows we shouldn't be doing this indiscriminately. And perhaps the duties and risks that come with this data and having this data outweigh the benefits of having it. So data governance is a really slippery animal. It's a very tough challenge sometimes, and perhaps some of my presentation will resonate with your own experiences, particularly if you're in-house, but maybe if you're advising companies on direct marketing. And next slide. Here we go. When the PDPO was amended in 2012 to include direct marketing, companies in Hong Kong scrambled to understand how it would impact their existing marketing activities, of course. And they, of course, were very interested in how they could qualify for the grandfathering provisions. I was around back then, and this was a hot topic for sure. I think the urgency for these companies was the adverse public reaction. It was partly due to the adverse public reaction due to recent marketing-related violations of the PDPO by some well-known brands here in Hong Kong, but also the breach of the new provisions in Section 35. You could be fined directly without first needing an enforcement notice and breaching that enforcement notice from the Privacy Commissioner. So this got people's attention, and the quantum of the fine for direct marketing back then was higher than for breaching an enforcement notice. Following the amendments in 2012, which I think came into force in 2013, direct marketing complaints increased. It's fair to say that data subjects had been empowered, and data users had been put on notice that they needed to clean up their acts in respect of their marketing activities. Now, just on this slide, I want to highlight that the guidance note in the top right, the new guidance on direct marketing, is a really fantastic resource for anyone who wants to understand a bit more about this space, because it provides the law, but also some really excellent examples and use cases. So really worth a read if you haven't read it already, or if you need to learn about direct marketing requirements. And a highlight on the right of this slide, my definition here of direct marketing, or it should be direct marketing means, I've underlined addressed to specific persons by name. Ada, I must say, great persons think alike, because you did the same, because it's relevant to a point made later in my presentation. So just leave a mental bookmark there about this, and we'll come back to it. Now, what I'd like to do is talk through 4 thematic challenges that pop up for data users. And data users now all should have procedures in place, as Ada's recommended, to comply with Section 35. But of course, complexities can emerge in practice. Businesses, they need to educate and constantly remind their marketing, sales staff, analytics teams, frontline staff, and maybe especially their senior management about basic data privacy requirements, or apologies, direct marketing requirements. And even if they don't quite understand them, they have to be a little bit maybe afraid of them. It sounds bad, but for example, marketing teams should recognize the existence of your opt-out list, or your marketable, non-marketable list, whatever you call it, and understand that the consequences for not respecting it could be worse than season 8 of Game of Thrones. And if your business understands that customers can opt out at any time, then maybe that will make them just a little bit more retrospective or introspective before they start spraying your customers or their customers with marketing materials. But as this slide shows, there's always room, even with education, for operational mistakes and errors. Frontline staff, new joiners, fresh graduates, bless their hearts, can always gum things up. And so it's really important in an organization to build hardwired checks and stop gates that prevent breaches where they occur, and prevents errors where they're most likely to happen, perhaps even making them impossible if you can build that kind of control into your processes. This is much more effective than relying on a procedure document sitting in an unloved shared directory somewhere. To err is human, as they say, so do what you can to make it hard or impossible to err. And think, even if your staff, bless their hearts, get everything right, there's every possibility that one of your vendors, for example, a printing vendor could make an error and send thousands or whatever number of direct marketing solicitations to non-marketable customers. So vendor management is another important piece of the puzzle. And the last tip here, in terms of operational errors and mistakes, is consider splitting marketing initiatives and outreach into sections or tranches. If you do have an error that occurs, you can catch it early, and not across your entire customer base. And what's also very important is that you'll know who's been inconvenienced, because it's an identifiable and hopefully small set of people that have been the beneficiaries of an operational error. Now, moving to the second challenge, I think if you're in-house, you can all relate to this. Enthusiastic marketing teams. It's really important to keep your marketing teams on a tight leash, particularly in Q2 of the past couple of years, when COVID restrictions have loosened and businesses started scrambling to catch up on their annual sales targets. You may have noticed this trend yourself. Now, servicing messages are not marketing messages. So I'm drawing that distinction, and they're not subject to the requirements of Section 35. You can send servicing messages to existing customers all you want, regardless of whether they're opted out of receiving marketing. So sometimes marketing teams, bless their hearts, might be tempted to test the boundary between these two kinds of messages. So you need to police this line very closely. Or they may try to insert just a little bit of marketing, no one will notice, right, into an otherwise entirely servicing message. I think the message here from me is to make sure that you have someone that looks at these customer messages before they go out. someone that knows the difference between a servicing and a marketing message. And even if the PCPD is satisfied that a message is a servicing message, your customers may not be as interested in these fine distinctions. So extra incentive to exercise some care. And broadly speaking, with your marketing teams, it's very important that they have complaint risk, privacy or direct marketing complaint risk factored into their calculus when designing these campaigns. Generally, businesses need to keep a holistic view of the messaging customers receive through varying channels, when and how frequently, or they can risk overwhelming or annoying their customers, particularly if you have a very large business with a lot of customer touch points. A little known fact, you can annoy customers even while complying with Section 35. Now, moving to the third of the challenges, confusing opt-out journeys. This really is very difficult to manage in a large organizations. If you have, for example, different opt-outs for marketing for different business lines or product lines, just customers will not distinguish between them. They'll see the brand name, that's it. So for example, if a customer does not want to receive any shoes marketing and opts out of receiving shoes marketing, it's a bit of a rough example, but they are still marketable for jackets marketing, and you send them legitimate jackets direct marketing, what's the probability or the chance that they would complain? They might, because they would not appreciate or even remember potentially that they are still marketable for the jackets. And another question is, do you, if you're a company, have systems in place to adequately record and track these different preferences? And that's an important thing to have in place. Try to have clear, consistent language and tick box mechanics for your direct marketing opt-outs to avoid confusing customers. Avoid double negatives and other misleading tick box approaches. I mean, this can happen purely accidentally and not with any malicious intent. So you do need to scrutinize how these opt-outs are being designed and conveyed to your customers. The object is clarity and not ultimately to trick them into receiving marketing. And another point that is an interesting one that many will not have thought of, or maybe you have, it might seem like a good idea to just put a direct marketing opt-out tick box into every document or customer touch point you have, but it really isn't. Continuously offering your customers the opportunity, the chance to opt out does cause confusion, mistakes, and may even be coercive. You give someone 100 chances and they miss the last one, all of a sudden they're magically marketable. No, so you do need that overview of the customer experience, which again is very difficult sometimes to craft clear customer consent journeys. And the last point I'll make on confusing opt-outs is that it can be really helpful to have an online preference page somewhere that allows customers to manage all these preferences all in one place. And you can use this as your golden source for marketability status. So it's a very useful resource, and it really does add to a customer's ability to exercise choice and control over their marketing preferences. You can also include channel preferences. For example, I don't want to receive any phone calls, please. Ada, I guess we have that in common, but you might be willing to receive postal marketing. I'll open a letter and have a look at that. So maybe you can offer that optionality to customers so they can receive what they want without just blocking all kinds of marketing. Ideally, every data user should have a clear preference channel, easily found and often shared with customers. Now, the last challenge I want to touch on, if I can find my cursor, apologies, here we go, is privacy notice fatigue. It is a real thing. How much time do we realistically have to read all the privacy notices we're asked to read or we're confronted with? And can you expect your customers to read all these privacy notices? And if they don't, how can you say your notifications were effective? It really is a problem for everyone. Now, a few years back, after pretty extensive customer usage testing, legal advice, and even regulatory consultation, it really was a pretty big job. HSBC rolled out a shorter privacy notice for its retail customers. It retains the required notifications while greatly increasing its clarity and its likelihood of being read. We've received really very broadly positive feedback about this shorter notice. No complaints, which is telling. And we know for a fact that more people are actually reading it, which we think is it's a big win from the privacy side. So each data user, of course, will need to manage this balancing act in their own way, but clarity and maybe brevity has its value. And resolving these questions and challenges, the ones I've just described, can also often involve subjective judgment calls. Now, no one likes the ambiguity of a subjective judgment call, but we do have an advantage in this respect in that we all have personal data, and we should have an innate sense of whether a data processing activity, a direct marketing initiative, or any processing activity at all might annoy or be viewed as a little off base by a customer. And often we are the customers as well, so we should have this sense. So try to act ethically when you're in these gray areas, act accountably, and really ask yourself, how would I feel if I were treated this way, or if this were my personal data? Now, I think what I'd like to do now is pivot a little bit to what marketing practices, how they've evolved over the past 10 years. The last decade, and I think this cartoon is funny, special thanks to Tom for this one. The last decade has seen a lot of change in marketing practices. It's really a lot more data-driven now, right down to the individual customer level. It turns out that marketing, targeting your marketing at people who are more likely to want your products actually works if you're trying to sell your products. And knowing your prospects allows you to tailor those messages to be maximally impactful. Knowing your customers can help you to tailor your products and services to better serve their needs. It can also help you to cross-sell or upsell to them. So you can see how powerful this more targeted marketing actually is, but of course, to do it, you need to collect more data. Now, fortunately, due to the time most of us are spending online, we are all now leaving massive digital footprints behind us everywhere we go, pretty much. So any device connected to the internet could be helping create this footprint for you or of you. And profiling, although it's not itself direct marketing, PCP guidance says that collecting personal data for profiling purposes that are not related to the services that you're providing, so they're for a different profiling purpose, should only be voluntary, which is a really good, important note to make. But it's interesting now that sometimes it's a bit of a moot point because profiling increasingly is the service or a huge part of the service. So it's a bit inseparable now. Can you imagine Netflix, for example, without program recommendations? I would be watching a lot less Peppa Pig. And this is another thing I can blame my children for. I'm not holding any grudges. Now, before we skip to the next slide and explore marketing just a bit deeper, it's worth stepping back and asking, do people appreciate targeted marketing? This is an interesting question, and marketers will tell you, yes, of course, everyone wants targeted marketing. It makes it more relevant to people. Maybe. 15-year-olds may not want to see ads about arthritis cream. That's pretty hard to deny. But what's interesting is that older people may be even more annoyed to receive ads about arthritis cream. I find personally personalized ads to be a little bit invasive, but I also get annoyed when a personalized ad that I receive has made some incorrect inference about me because it's not personalized enough. So obviously some complex feelings here, and perhaps the takeaway is to keep your targeted marketing away from being a little bit too creepy. So Ada, I guess one recommendation for the upcoming amendments to the PDPO is to include a creepiness test. I will leave that out there for you to consider at your discretion. There are also many ways to make profiling and targeted marketing less creepy. For example, you can categorize your customers into buckets. This avoids being too personalized in your outreach, but of course, do also be careful how you label those buckets, and you might not want to tell your customer that you put them in a bucket. But that is a good way of reducing the creepiness of your outreach by making it just a little bit less personalized. Now, if it's true that processing personal data involves extra responsibilities and risks, it would be much easier, surely, if someone else did this for you. Well, yeah, this is the business model of some of the most profitable companies on earth. I think you can see them there in the window looking in this comic. These companies collect the data, a lot of it from their own online platforms. They do the profiling of their users, and they either sell you their insights or they use their platforms to do the marketing for you. And it makes a lot of sense because you're not the data user in respect of this profiling. You're not doing the marketing. Essentially, you're just buying ad space in someone else's online environment. And if it becomes undesirable or unfashionable, you can just stop using the service. Now, you may also have noticed that people are spending more and more time in these online environments. And this is the final point I'd like to make in my presentation, maybe a bit of a futuristic look. Not only can a ton of personal data be collected in these online environments, data that enables profile building, but these environments are also really great environments to market products and services to people. People's experiences in these environments can be totally controlled and shaped to deliver marketing in innovative ways. And harking back to the bookmark and to Ada's comments, not necessarily addressed to people by name. You don't need someone's name when you can just put billboards and product places all throughout your own customizable digital environment or experience. So I think a key point here is that direct marketing rules, the ones that we've been discussing, may not apply to many of the marketing activities in these environments. And I think maybe that was the point that Ada was making, that it's not a loophole. Maybe that's intentional. But I would remind that even if Section 35 doesn't apply, the privacy principles will still apply because it's personal data. Now, on my last slide, perhaps you've heard of the Metaverse. Well, essentially, it is the next level of digital immersion. It's the digitization of human activity, where physical and digital lives converge. Now, I'm hearing a little bit of an echo on the line, so if maybe we can look at that. I don't know if other people are hearing that as well. But in the metaverse, activities like work, play, socializing, shopping, and all kinds of commerce, they happen in parallel and in connection with the physical world. And bit by bit, whatever you think about the metaverse, we may all be forced into it in some way or another. It's not hard to imagine a future where people or their avatars routinely travel through the metaverse, visiting different worlds, not unlike how we visit websites today. And what takes place in these different worlds may be as important or almost as important as what takes place in the real world, or the physical world, I'll say. And of course, these popular worlds that people visit will be immensely valuable because of the economic activity taking place in them, the services that can be sold, the ad space that can be sold, the rents collected, and also, of course, the data collected. So all this might seem a bit alien to you now, but it probably won't seem so alien to your kids. Where do you think they've been for the past 2 years? They've been thrust online due, I suppose, to our pandemic response. And companies are already meeting them there, targeting them and profiling them there. So it might seem like a little bit of a remote idea to you, but trust me, your kids are all over it. Now, the metaverse itself is in its nascent stages, being conceptualized and built, and may even seem abstract or silly to you. But recall that even though many early internet companies went bust in the dot-com bubble, the thesis that was driving the bubble was not wrong. Pets.com is no longer around, but the internet did change our lives. So you may not want to spend time with Zuck in the metaverse, but chances are you won't have to, because we may all be spending more time there in the years to come. And I close my presentation asking the question, how are we going to protect people's privacy rights in the metaverse? Well, fortunately, this isn't my job to do or decide, but I think the ethical accountability framework issued by the PCPD in 2018 is a good start. It encourages data users to process and handle personal data in a manner that is, and I'm sure you've heard this before, respectful, beneficial, and fair, and hopefully not too creepy as well. So with that, thank you for your time, and it's been a great pleasure to speak to you. Thank you.
Thank you very much, Aaron.
Thank you, Wilfred,
for your sharing, and wishing you a very speedy recovery. And sorry that you won't be able to join our Q&A.
Yeah, I'll drop now. Thank you. Yeah, and I'll stop sharing.
Thank you, Aaron. With that in mind, I think our next speaker, Carmen, will follow on very well with this theme about practical applications, because I'm really interested in hearing her sharing and her thoughts, not just on the challenges about meeting the law or in terms of fulfilling legal requirements and obligations, but also essentially the balance between our legal requirements and also creating a culture from the perspective of user, and perhaps instilling even an accountability brand image from the companies and an enterprise perspective. So I'll pass the time to Carmen for your sharing. Thank you.
Thank you, Wilfred. Good morning, everyone. This year marks the 9th anniversary of the Hong Kong data marketing regime in Hong Kong. So let's take a look at how companies have adapted to the development of the regime since then. There are several areas that I would like to talk about today. First, the cases. Secondly, the commercial world, that is what the companies have been doing. What's in their mind? Do the companies prioritize privacy for consumers? Apart from regulatory compliance, what do data protection mean to companies in Hong Kong? And last but not the least, to look at the challenges in a culture against targeting ads and retargeting ads. So first, let's have a recap on the data marketing regime in Hong Kong. There are specific acts that data users required to do before they can use the personal data on direct marketing purpose. First, as Commissioner has mentioned, there is a list of prescribed information that data users have to notify the data subjects beforehand. Second, obtaining prior consent is a must. And third, response channels should be provided to data subjects for opt-in or opt-out. So let's take a look at the number of convictions here. For the first and second convictions, you can see that they happened in 2015. For the first case, the defendant was fined 30,000 Hong Kong dollars, and the second one is 5,000 Hong Kong dollars. So from this chart, you can see that over the past 9 years, there were on average 3 to 4 convictions per year. And most of the defendants plead guilty, and the reasons for breach of the ordinance is either the staff concerned may not be aware of the existence of an updated opt-out list, or the list itself was not updated. And there are a few cases involving the insurance agents and estate agents who have obtained personal data from work or other elsewhere, and then used that for direct marketing purpose for their own good. So in most cases, the defendants were fined in a range from 2,000 Hong Kong dollars to 10,000 Hong Kong dollars per charge. And the landmark case as of today, it's involved a telecom provider who sent 23 direct marketing messages and emails to data subjects in 4 months' time. And the defendant was fined in a total sum of 84,000 Hong Kong dollars. So what are the implications here from the figures? So comparing to the fines imposed by FTC in USA, for example, like the Facebook case or in the Mobi case, the deterrence effect of prosecutions under the regime in Hong Kong may seem debatable. But let's pause here. So in the long run, should laws and governments be the driving force for data protection in Hong Kong? I remember in the year of 2018, when the GDPR's commencement day was approaching, companies also start calling their professionals for help. Some of them may not have paid special attention to privacy issues before. That's why when the new regulations came out, they felt frustrated and annoyed. They sought legal advice because of the uncertainty on enforcement. And I believe everyone knows that for the GDPR, the fines goes up to 10 million euro or 2% of the global overall turnover, which companies cannot ignore. But the thing is that simply staying compliant cannot be the end goal. So what is sustainable in the long run? A win-win situation. But what is a win-win situation? That is, data users and data subjects, they are gaining value and benefits from data exchange and sharing. So let's take a look at what companies do in Hong Kong. What does personal data protection mean to them? The easiest ways to learn about a company's core values and areas of interest. It's from their annual report and also recently the ESG reports. And we discovered that more and more companies have highlighted the measures on data protection and security in the ESG reports, which is a very good start because they have become aware that people nowadays do highly value their data privacy. And there are several things that companies would highlight in their reports. For example, one, the existence of a privacy policy. Second, they have conducted internal trainings and workshops for staff to enhance their awareness on data protection. And as far as information security is concerned, they have executed audits and reviews. So from theory to practice, let's look at some of the daily examples. So when we all go to a website to search something, I think you guys will not feel surprised to see tons of roadblocks that coming all over the place on a website that blocking your view. The roadblocks that I'm referring to are actually the banners, the flashy pop-ups. They are the cookie banners that for the people to opt in and opt out. For these examples, you can see that the designers have actually put some thoughts on the user's concern. That's why the banners are actually set at the bottom instead of flying here and there over the website blocking you. But let's see. So before the users decide to opt in or opt out, they would like to know what kind of data that the companies would collect and they would use and how they would deal with the data. So at this time, the users would be directed to pages and pages of policies. And sometimes the policies are so long that even longer than the submissions that we make in court nowadays. So imagine that you have to browse 10 to 20 websites, not just on your mobile phone, and also on your laptop or desktop and other digital devices. So maybe a raise of hand, how many of you would actually read word by word the whole policy before you click the accept and reject button? So in the privacy community, we got this term to describe the interfaces that nudge users' behavior towards choices that he or she may not pick if the options are presented to them differently. These are called the dark patterns. For example, like confusing language, complex language, interfaces that encourage people to pick one option over the other, interfering pop-ups. So there is one common thing among these features. That is, there is no real option for configuration for users. So here comes the fallacy. Many companies believe that with this kind of mechanism, this can shorten the user's time in thinking, and then they will just provide consent so as to stop going through the hassle as soon as possible. But the reality is that because these kind of pop-ups or interfering interfaces, they are quite intrusive or scary. So users tend to be more careful. And if they do not have time and they do not want to take a look at lengthy policies, they will simply close the window and just jump to another site. So for companies who decide to let people have a choice on data processing, they should let them have the ability to exercise that choice. So what does mean by the transparent and meaningful choices? So you can see this example here. So on the left-hand side, there is a box. So it's a small paragraph, and there's assistants that guide the users to manage their own consent preferences and also make informed choices. The data are categorized into 4 categories. That is, first, strictly necessary, also functional, analytical, and also targeting. So under each type of data, there is a cross sign. So when you click that cross sign, you can see a small paragraph that telling people the purpose of collection and also what would happen if you do not provide the data. And after the users have set their preferences, they will need to scroll to the bottom and click the Confirm My Choices. So this is another example that you can see it is not necessary to have those flashy pop-ups flying here and there for the seeking consent. And I'm sure those who have been using this brand's phone are familiar with the features that they have a settings for users who can customize their privacy preference for different applications in their phone. So we have been talking about what the companies are doing and what they think. So let's take a look at the consumer's perspective. So consumers, of course, they are concerned about their data privacy. When they cannot see, when they are not well informed, they are kept in the dark, and they are afraid that their data may be used behind their back on purposes that they don't want. But on the other hand, they know well about the benefits of sharing data with businesses. For example, like getting free product sample, discount on future purchase, gaining personalized experience, and also learning new products that are suitable for their needs. So when their concerns are addressed, actually this will create positive impact for companies and also consumers. So what companies should do is to treat the customers in the same way as in the real world. So imagine that when someone walks into your shop, you will not force them to buy their product as soon as possible. You will interact with them, you will answer their inquiries, and then give time to think and let them make the decision at the end. So lastly, let's take a look at the challenges on targeting and retargeting ads. So these are the products of behavioral advertising. The digital platforms and websites, they gather information from digital footprints and also online activity. They collect the data, analyze it, and then deduce the type of ads to send to the users. So you can see these interfaces and also ads that have actually been appearing on my own account. So for lawyers, we do on and off need to search technical terms and do translations online. And all of a sudden, the platform thinks that it's time for me to brush up my English skill. So they kept on sending me these English lessons ads. So actually, you see, it's the same company. And this is another example. You may recall from the previous slides that I've shown on the cookies banner. And for the purpose of preparing this presentation, I have landed on this brand's website for a few times. And now the platform thinks that I must be a fan of this brand's product. So whenever I search something at work or browse internet during my leisure time, they will direct me to see these ads of this product. So the issue here is that the original purpose for this existence of targeting and retargeting ads actually vanished and is long gone. Because for personalized marketing, the companies wish to ensure the brands to reach the persons that are genuinely interested in what they have offered. But apparently this is not the case here. So what companies can do to fix the situation? So we can see the example on the left. When you go to this website and you scroll down to the very bottom, there is a small box that asks you in what capacity you come to visit the site today. For example, if you are a customer, you come to the site to manage your account, or you are new, you want to learn about the products there, or learn about the discounts or deals, or sometimes maybe job candidates that they want to find a post with the company. So with this information, the company will have a better idea of the purpose of each user's visit, and so they will be able to generate more personalized ad to the suitable ones. And on the right-hand side, you can see that this is an ad that allows the interested party, the genuine interested parties, if they want to know more about the site or the brands or the products, they can sign up for updates. So in exchange, they will have a discount of 15%. So you can see the ad is straightforward, clear, no hidden information, and that's what the customers want. So the key takeaway is that to have a responsible data practice is very crucial, because this not only just build trust, but also provide opportunities for business growth. So thank you very much. This is the end of my presentation. And if there is any question, you can contact me through the QR code as well. Thank you very much.
Thank you very much, Carmen. We've now entered into the Q&A session, so do remember questions are open to the floor, and I will try to open up the Zoom questions as well as to exercise my own prerogative as the moderator to facilitate some of the discussions. So let me just open the questions. Before we turn to the Zoom questions and also any questions from the floor, allow me to, as I said, excuse me, exercise my discretion as a moderator and to benefit myself, because I can already pick out a very recurring theme from very fruitful presentations from all speakers, specifically from Commissioner Chung's emphasis about the direct marketing regime on the need to address someone by name. And to follow that with what Carmen has just said in the digital and online environment, and also what Aaron has repeatedly said in his slides as well, that sometimes we do ignore the fact that online activities, and particularly when our data, which doesn't seem to be processed in a conventional way, be it a paper form, be it a collection in a tangible manner, then sometimes as companies and data users, we seem to have placed a lower emphasis from a compliance perspective, and somehow seem to get away from that kind of compliance hurdle. And I think in that spirit, I'm interested to, again, sorry, because we're all lawyers here, to go back to a little bit about the law, perhaps to ask Commissioner Chung to share some of her thoughts about perhaps what's the regulatory perspective regarding a marketing activity in situation A, it's a B2C situation, and versus situation B, where it's a business-to-business or enterprise-to-enterprise marketing communication.
Thank you. Thank you, Wilfred, for the question. Talking about B2C, business to customer, I think that is the normal scenario, and the usual rules would apply. But talking about B2B, business to business, I would say the scenario is more complicated, because as you can remember from my presentation and the presentation of other panelists, one of the essential criteria under the law is that the message or the information has to be addressed to specific persons by name. So insofar as the message or the advertising is addressed to a company, not to an individual, I would say it falls outside the purview of the PDPO. However, insofar as the business is a sole proprietorship or a partnership, and the message is addressed to the sole proprietorship by his name or the partner by his name, then it will be caught again by the provisions of the PDPO. Therefore, it really depends on the situations in question. I would like to also point out that it's rather common for salespeople to approach, for example, an employee of a company. So what happens to that? I would say insofar as the employee's personal data was collected in his official capacity, the call was only directed as, say, the marketing manager or the procurement manager of a company, and the marketing efforts relates to a product for use in the office, for example, an office photocopier, and the marketing efforts target the company in question rather than the procurement manager himself. In that case, it will also fall outside the purview of the PDPO, because under the PDPO, we are talking about information or messages addressed to specific persons by name. So if the marketing efforts target the company in question, and the employee was only a representative of the company, that will fall outside the purview of the ordinance.
Thank you, Commissioner Chung. I think that raises a very good point, if I can extend that a little bit further as well. Perhaps not just in a B2B specifically addressed to someone in an official capacity situation, but also what Carmen has talked about, for example, dark pattern, whereas there's sort of an explicit absence of conventionally identifiable things like by name. It might not address me as Mr. Ng, but it somehow knows my behavioral patterns. In those situations, maybe Carmen, in your observations, what, again, also in the spirit of your presentation, what are the things that enterprises can perhaps do better, knowing that obviously there is a personal data element there, there's a processing there, but somehow enterprise and maybe your clients need to be aware that this doesn't get them away from direct marketing regime and also the PDPO framework.
Thank you, Winfred. So often people have the feeling that there may be a conflict between the compliance with the laws and also doing direct marketing. And people tend to criticize the laws they are not catching up with the technology change, or if they up to speed, endless debate will result. So maybe let's step back and think about the original purpose for having data privacy laws. The laws aim at allowing the data subjects to regain the control over how the personal data is to be used by whom and and the reasons for that. So for fines and penalties, they actually serve as a warning and alert to companies to press them to review and evaluate what they have been doing in the past on data processing. Of course, every company wants to make money, but having accountable practice doesn't mean that this will contradict the goal. In fact, in the opposite, this will create competitive advantage, allow them to outperform their rivals. So when the people knows what the companies are doing, they actually feel safer. They are more willing to engage, and this will build trust. And for example, the consent preference that I showed earlier in my presentation, you can see the whole consent seeking process is not just a one-way thing. From the interface, the language is used, you can see whether a company actually cares about the data subjects, whether they respect their ownership rights of over their personal data. So when the data subjects feel that, they will be more willing to shop at your site instead of the others.
Thank you, Carmen. I think before I turn to some of the Zoom questions, may I just check if there's any questions from the floor? Yes, the gentleman in the second row. Yes, please do.
Hello, Ada, you are not only the privacy commissioner, but you were formerly the company registrar. So I want to ask a very basic question. A lot of people come to my organization, which is incorporated under Hong Kong, to ask for my membership list. And anybody under the company's ordinance can come and get that data. So I normally fend them off by exactly using marketing rules. I say, I can give you the information, but you can't use it. So then they fend off themselves, they just stop. But I think that there is a little bit crossover from the company's ordinance and the PDPO, that little gap, which public seems to be able to go to a company to get the membership list when they are not a member. So is this something that you could actually consider for reform?
I think I'm no longer the registrar of companies. I think this question should be directed to the incumbent registrar of companies. I think it is a good question, but if we are looking at it from the angle of companies law, the basic concept of opening up the register of membership to the public is to enhance the transparency or ensure the transparency of anyone who operates the company. Because a lot of stakeholders, such as customers, creditors, they know to need the members of the company. And that is why under the company's law, there is a regime for members of the public to go and take a look at the register of companies. If I look at it from the angle of privacy law, actually it's also covered by some basic data protection principles. I would say insofar as a register is kept, that is a purpose for the collection of the data. And anyone who collects that data from the company's register have to observe or will be restricted by the limitation of use of that register. And therefore, he cannot obtain the data from the members register and use it for direct marketing purposes, because it is only meant, I think there's a section in the company's ordinance, section 45, saying that you can only obtain information from the register for a specified number of purposes. For example, for the purposes of dealing with the company, for the purposes of knowing who are the directors or members of the company. So you are still subject to that limitation of use principle under the privacy law. So there's essentially no conflict between the two areas of law here. I hope I have answered your question. But talking about law reform, I'm no longer the registrar now, so I better leave that question to the incumbent registrar.
Thank you for your questions, and thank you, Commissioner Chung. I'm aware of time, so again, if I may exercise my discretion as moderator, I'll try to group the Zoom questions into one, perhaps preliminary single response by me with the blessing of Commissioner Chung. I know that there are already a few direct marketing regime specific questions, which I think I know that they can be found in a direct marketing guidance, namely how to opt out, and particularly a question on whether push notifications can be bundled with service notifications, and I think that would be an issue of the bundling of consent. And also, last question regarding whether we can just state a general message that this is not a direct marketing message, which I believe wouldn't already constitute, wouldn't avoid you from being regulated under the direct marketing regime. And again, to Aaron's earlier point, I think we can all find a lot of insight and resource in direct marketing guidance by commissioners' office. With that in mind, I think this about time, and thank you very much everyone for your attendance online and physically here in this room, and we hope you all enjoy the rest of the conference. Thank you.
Thank you, Aaron, Ada, Carmen, and Wilfred. Could I ask you to stay on the stage as the Law Society would like to present you a souvenir? May we invite Mr. C.M. Chen, President of the Law Society, to proceed to the stage and present the souvenirs to our panelists. Mr. Wilfred. Let's take a group photo. Thank you, President, and thank you again for our panelists. We'll now take a short break before we move on. Please return at 11:10 a.m. for our next panel discussions. See you after the break.